Aleda, I still act for Mr. Malema and the EFF with Mr. Premitt. Thank you. Aleda, yesterday I had made the suggestion that Section 10 of the Equality Act is too wide and should be restrictively interpreted. I did that by reference to the case of Khumalo and the case of Masuku. Overnight, I found an additional piece. It's an academic piece by Dr. Milo, Glenn Penfold, and Anthony Stein, who make exactly the same point. We asked for those additional authorities to be handed up. It is from the widely read textbook on constitutional law of South Africa, initially written by Chaskalson. I think it's now edited by Bishop.
Yes. So just have their additional authorities that will come to.
Yes. So if your leadership pages through to, it should be 87, but they're not numbered at the top or at the bottom, but in the middle, I think it is, it's the fourth page in the middle where it says piece 87 towards the end, and this paragraph starts with a first noticeable characteristic of section 10.1 is that it does not envisage that the hate speech must incite or persuade others. And then he goes on with the discussion. And the following page, he makes the point where he says in the middle, in the second line, the test is overly broad and vague. Now that's the test in section 10. And then he says the second and perhaps more important difficulty is that the harms contemplated in this section are on their face very wide. And then he says speech is prohibited if it appears to be intended to promote or propagate hatred, to be harmful or to incite harm or to be hurtful. The phrases hatred, harmful, and harm are, if given the meaning accorded to these phrases, in the context of section 16.2c, not problematic. So he first makes the point that this is too wide. It needs a restrictive interpretation that is consistent with section 16.2c. And then he says the difficulty is the use of the phrase hurtful. If interpreted literally, in other words, if you just hurt someone's feelings, if interpreted literally, this phrase would prohibit a wide range of expression, such as robust opinions on racial issues or gender-insensitive jokes. Such an approach would run counter to the constitutional commitment to freedom of expression and should be avoided. And then he gives three possible ways of a narrow construction to section 10. And those are set out in the article right up to the following page. But the point to emphasize is that even academic writers, and Mr. Milo is in fact an expert in the area, even academic writers have noticed the problem with section 10, that it is too wide and that the courts should try as much as possible to interpret it consistently with section 16 of the Constitution. And then he gives the three methods of achieving that interpretation. The next point that I need to finalize from yesterday is the question what was raised by our learned friend, which is you have to read occupation or journalism as an analogous ground. It's just to refer to the case of Khumalo as at page 28 of the bundle of authorities. Now we know that Justice Sutherland found that in that case, the words used constituted hate speech. Page 28 in paragraph 1 explains precisely the type of words that were used in that case, where Velapi Khumalo essentially said, I want to cleanse the country of all white people. And then he continues, I don't want to read the rest because it's particularly offensive. But the fact of the matter was that he wanted in his speech to rid the country of all white people. And that's why it was easy for the court to say that is precisely the type of speech that Section 10.1 is aimed at, because it is a propagation of hatred towards a racial group. The same thing happened in the case of Masuku. It was a classification of people in relation to their religion, Jews. And both these cases, Kumalo and Masuku, illustrate the reach of Section 10. The third case we referred to is Kolane. Kolane was homophobic speech, where Mr. Kolane writes an article saying that very soon in this country we would have to legalize marriage between animals. It's that type of speech that Section 10 is intended at governing. Speech that dehumanizes on the ground of an innate characteristic, things that are unchangeable or extremely difficult to change. We have overnight also found 2 additional authorities, your ladyship has them, dealing with the question of the meaning of an analogous ground. So we know that primarily the purpose of Section 10 is to protect people against abusive speech, but that speech which is concerned with innate characteristic. Of course, the language of the Act says there may be grounds that are analogous, but those grounds we argued yesterday by reference to the 2 authorities, Labi Odam, as well as the Huxon case, that those grounds must themselves be linked in some way or the other by an innate characteristic. There are 2 judgments. The one is Makwicana. Your ladyship will see that we've highlighted Makwicana at the top of the page, which deal with what an analogous ground. This one was directly under the Constitution, under Section 9 of the Constitution. And the paragraphs that we submit are relevant start from 108 up to 115 of that judgment. So in paragraph 108, they deal with the test formulated in Huxon. And then in 109, they deal with Labi Odam, which is the case that we highlighted yesterday. And then in 110, they deal with the Pillay case. And in 114 and 115, those are the most relevant. 114 says, in short, the Constitutional Court's selectivity about whether, when, and what comparators it relies on injects flexibility into the nascent stages of our jurisprudence, a welcome difference from Canada. In its formative jurisprudence, the Supreme Court of Canada used comparators as indispensable tools at times with unsatisfactory results, and then she explains. And then it continues to paragraph 115. Particularly pertinent to this case is Pretoria City Council versus Walker. Race was listed as a ground of discrimination, thus shifting the onus to the council to prove that discrimination was not unfair. The council had used different utility tariffs for black and white residents and exempted black defaulters from legal action for non-payment of utilities. Arising from the choice of race as a ground of discrimination, the comparators were, on the one hand, mainly black residents of historically black townships, and on the other hand, mainly white residents in historically white municipalities. The minority persisted that the differentiation was based on objectively determinable characteristics of the geographic areas and not on race. And then she says the majority disagreed, saying that to ignore the racial impact of the differentiation is to place form above substance. In the South African context, racial discrimination, often indirect as in Walker, and in this case, cannot be ignored. The Constitutional Court had to respond to race as the chosen ground of discrimination. Another ground of discrimination the Constitutional Court could have recognized was the relative socio-economic status of the black townships to the white suburbs. At 116, and your ladyship, just to give context, this was a case of whether or not black informal traders in the city of Durban qualify for protection under Section 9 of the Constitution, even though the informal trading on its own is not mentioned in Section 9. But this is how the judge gets to the conclusion. Street traders are such because of their socio-economic status. Not only Africans and other black people are street traders. White street traders may also be discriminated against on the ground of their socio-economic status. On the face of it, the bylaw is racially neutral. However, apartheid layered poverty over race. The degree of coincidence or intersectionality of race with socio-economic status results in the greatest impact being on Africans. So we see that the only way to do this is to draw a link to race. And the only way the judge ultimately concludes that it is a comparable ground, it is because of the intersectionality, because of the socio-economic status and race. So again, the innate characteristic of race is still present, even where you are drawing a comparator. Then another case that deals directly with the Equality Act, and the Makwicana case is about Section 9. A case that deals directly with the Equality Act is decided in December 2018, reported in the 4th edition of the South African Law Report, Social Justice Coalition. And the paragraphs there that are relevant are from 57 to 64. And now, briefly, Your Ladyship, what had happened in that case, the question was the uneven distribution of police resources to black townships, like Khayelitsha in the Western Cape. And what the applicants had argued is that the uneven distribution of policemen to black townships constitutes discrimination on an indirect ground of geographic or socio-economic status, but that is ultimately linked to race. And so if we look at how the court reasons this out, from paragraph 57, and they start with outlining the question that have to be answered. It is with poverty, at paragraph 57, it is with poverty that it must be established whether it qualifies as an unlisted ground in terms of para B of the prohibited grounds. Now, this is para B of the Equality Act. Since poverty is an unspecified ground, the first leg of the inquiry requires considering whether differentiation on this ground constitutes discrimination. Whether poverty qualifies as an unlisted grounds of unfair discrimination would have to be tested against what the Act contemplates as any other ground, and then it highlights the Act. The applicant submitted that though there was no occasion on which a court had considered whether poverty was a ground for discrimination, there is a wealth of decisions which have applied analogous grounds to find that there was discrimination on an unlisted grounds. Again, the applicants found support for their submission that poverty qualifies as an unlisted grounds of discrimination in a number of decisions. And then they deal with what those decisions are. And then in paragraph 59, one of the judgments in which the Constitutional Court found unfair discrimination based on an unlisted ground was Huxon and Lane, and then they explain what Huxon and Lane found. In paragraph 61, the question therefore is whether poverty is a ground of discrimination which causes or perpetuates systemic disadvantage, undermines human dignity, or adversely affects the equal enjoyment of the rights and freedom of the people of Khayelitsha in particular, or the people of any other areas covered by the Red Path statistical analysis in a serious manner that is comparable to discrimination on any ground in paragraph A. And then the explanation is given. Then in paragraph 64, the applicants further submitted that poverty undermines human dignity because it is an immutable characteristic of a person, or that treating someone differently on the basis that was inconsistent with the ideas of equal protection and equal respect. For support, the applicants called on the judgment of the Constitutional Court in clicks, and then it goes on. And then it says, according to the applicants, discrimination on the basis of poverty clearly impacts on the socio-economic status protected in the Constitution, as it adversely affects the equal enjoyment of the person's right in a serious manner, and it goes on. And then eventually, the court accepts the submission made by the applicants. So, my lady, what do we say then about the Social Justice Coalition case? What is apparent from both the judgments, Social Justice Coalition, as well as the Makwicana case, is that it is possible to derive an unlisted ground, but deriving an unlisted ground must itself be linked to a listed ground. In Makwicana, it was the intersectionality of African street traders and the discrimination based on race. In the Social Justice Coalition case, it was the unfair distribution of resources to black townships. And the court specifically makes the point about innate characteristics. So factors like geography, of course, may be taken into account. But the reason we take those factors into account is because of the very purpose to Section 9 of the Constitution. The point of Section 9 of the Constitution was that the country was drawing a decisive break with the past that was based on inequality. And we know what the basis of inequality under apartheid was. It was race, it was gender, it was sex, etc. That is why those grounds were chosen. So one cannot now impose arbitrarily chosen grounds where there is absolutely no evidence of the group or the category having suffered systemic discrimination in the past. One cannot simply choose today that I want journalists to be a protected category, because there is just no linkage to Section 9 as a ground of discrimination. And I don't want to repeat the submissions we made yesterday about the dangers and the risks of choosing profession by profession for protection. And the Social Justice Coalition case, we say it's particularly instructive, especially because it is a full bench judgment of the Western Cape High Court. Could I then move to the second topic of my address? Your Ladyship remembers that yesterday I took the court through the speech that was made, the 20 November speech made by Mr. Malema outside of the Justice Zondo Commission. What also happened is that our learned friend relied directly on the tweets that were shown on the EFF Twitter page as Mr. Malema was talking. And it was somehow suggested that if you read those tweets, the way the speech was tweeted by the EFF, that could somehow create an impression that Section 10 was violated. It's important to go through those tweets. There are 4 of them. They start at page 29 up to 32. The first one at page 29. Now this is the EFF itself speaking. The first one is, let us attack fighters. Where we meet the enemy, we must crush the enemy. When the enemy raises its ugly head, don't hit the head, cut the head. That is at 4:24 p.m. Shortly thereafter, at page 30 is the next tweet, where Mr. Malema names Bruce, Dupree, Munusami, Hafaji, Mohudu, Gasa, and DeForce, and says those are the Ramaphosa Defense Force. I've shown your Ladyship the context in which this was said. But if you look at 31, and again, it's a couple of minutes later, I think it is 2 minutes after the tweet at page 30. This is what Malema is quoted as saying. Everywhere you see their names, you must attend to them decisively. But look at what's tweeted next. They are no different to Bell Pottinger, who was hired as a machine for the Guptas and Jacob Zuma. That immediately shows you, if anyone reads this and they know Bell Pottinger was a spin doctor, a propagandist. The criticism is that these journalists are propagandists. That may be an unfair criticism, because these journalists may be doing their work honestly. But it's not hate speech. At page 32, the last tweet appears. Mr. Malema is quoted. These people I'm mentioning by name, you must engage them in a civilized manner and not violently. And then he expressly explains what the position of the EFF is on violence. Violence is for those who are empty in the head The EFF thrives on superior logic. So if you read these tweets that were intended to transpose the speech, the dominant impression is that there is a criticism of identified journalists for behaving like Bell Pottinger. In other words, for being propagandists. We will also get the clear impression that Mr. Malema is expressly opposed to violence and that the EFF, its mode of engagement is what he calls superior logic. It is only by lifting page 29 out of context that you get to the outcome that Mr. Berger urged upon the court. But that simply goes against logic, and that goes against authority by the Supreme Court of Appeal. And so, neither the speech itself nor the manner in which it was tweeted gives you any impression at the level of interpretation that this was hate speech. The argument goes further from our learned friends. It says, forget about the 20th of November speech. Look at the subsequent conduct of the EFF. Here, my lady, we must draw a distinction. Your ladyship remembers in my opening remarks, I said that I'm going to argue to your ladyship that the law does not impose liability on the EFF in respect of speech made by other people. It imposes liability on the EFF in relation to speech it itself makes. This is clear from the provisions of Section 10 itself. We don't have to go beyond Section 10 because this is a Section 10 inquiry. We go to Section 10, which is at page 69 of the Bundle of Authority. The opening line of 10.1, subject to the proviso in Section 12, no person may publish, propagate, advocate, or communicate. The prohibition there is on the person publishing, on the person propagating, on the person advocating, on the person communicating words. It's not indirect or derivative. The prohibition is the EFF may not publish, propagate, advocate, or communicate words. If the words are communicated by someone else, the prohibition is against that other person, not against the EFF. The same applies to harassment, which is in Section 11. No person may subject any person to harassment. It is a direct prohibition against the conduct of the EFF, a direct prohibition against the communication of words by the EFF. We listened yesterday to our learned friend, hoping that we would get authority for the proposition that this act, in Section 10 in particular, must be read to mean that the EFF is also responsible for the conduct of third parties. We got none. In circumstances where it is expressly pleaded in the answering affidavit that the EFF denies responsibility for the conduct of unauthorized Twitter bots that are abusing people online. So, we have to get the law right on this. The prohibition is against the EFF. It is not against a derivative, third party, unknown, unidentified, and unidentifiable. It does not help for our learned friend to read out online abuse that emanates from third parties. Those third parties must take responsibility for abusing journalists. What is wrong is the scapegoating of the EFF. So, what did the EFF actually do? This, again, is not difficult because we have the evidence of what the EFF did. Let's look at the EFF tweets. The first one is at page 51. This is from the president, Mr. Malema. And this is in the context where Sanef is asking for a meeting with the EFF. And what Sanef does is not just to write a letter to the EFF privately. It tweets about it publicly. And you cannot expect in those circumstances that Mr. Malema is not going to respond by a tweet. Because if you look at page 51, the fourth tweet, Sanef publicizes on Twitter the fact that it has asked the EFF for a meeting. There's no need for that. What Mr. Malema then does is to respond immediately in kind. I'm prepared to meet you on condition you do not bring racist things like this young white boy called Adrian Basson. Now, if we look at this, we just have to compare it with what the SCA said in Masuku. To call someone racist is not hate speech.
Page 60.
Page
60 of the authorities manual, 60.
It's page 60, my lady, I am told, of the bundle of authorities.
Yeah, feelings one is Para 31.
Where they specifically say racism.
Oh.
It is 59, my lady, sorry, paragraph 26. So if you look at 59, paragraph 26, now this is where Mr. Masuku had called white people racist. They complained about that as well and called others Zionists. This is what Dambuza J.A. states. Further, none of the other offending terms, specifically racists, fascists, and friends of Hitler, either on their own or within the statement, connote religion or ethnicity. The terms may be irrational, offensive even, and even insulting. Threatening or unsavory words in the statement, such as bitter medicine and perpetual suffering, are only metaphorical. Mr. Malema has told your ladyship that when he spoke of chopping people's heads, or chopping the head of the enemy, not a person's head, that was metaphorical speech. This is not the first time this has happened. It has been accepted by the Supreme Court of Appeal. And the reason why this continues being made is that we have to be tolerant of speech, tolerant of robust speech, because we prize freedom of expression in Section 16. So there is nothing wrong in Mr. Malema refusing to meet with Sanef, and of course responding publicly to them, because they themselves put the fact of their request to a meeting in a public platform. What are they trying to do? To embarrass the EFF? And so the fact that Mr. Basson was called racist is neither here nor there. In any event, his complaint is not that he was discriminated against on the grounds of race. His complaint is that he was discriminated against on the grounds of his occupation. And we know for a fact that the mere fact that he is attacked or accused of racism is in fact on its own not hate speech. The next.
He actually says it's a defamatory statement.
Yes. My colleague points out that in his affidavit, Mr. Basson complains that he was defamed by Mr. Malema. That may be, but that simply shows that he has a right to institute a defamatory claim against him. We were told that they have no alternative remedies. Well, defamatory claim is one of them. We look at... Yes, I will come to Brown. But in fact, I can tell you, your ladyship, now what the argument on Brown is. Reliance on Brown is really misconceived, because Brown was concerned with the electoral code. The electoral code imposes a duty on the EFF to make sure that it polices its supporters. And that is why it was found in Brown that the EFF had violated the electoral code because it failed to say no to its supporters. And this is why one cannot rely on authority outside context. we have to look at what Section 10 does. This is a Section 10 case. It's not an electoral code dispute. And it's not a defamation case. We look then at what the EFF does. And again, we have to make sure that we are confined with the EFF, because that is the statutory prohibition. At page 62, Ms. Haffajee says, Malema says in his speech, and the EFF turns it into a tweet which goes viral, we get attacked by EFF trolling army. It happens every day. Once marked like this, it's open season. This must end. That is Ms. Haffajee. Now we know that Ms. Haffajee is not part of this case at all. We also know on the affidavit of Mr. Malema that Ms. Haffajee in fact attends EFF press conferences. And when she is there, she engages with the EFF. What Mr. Malema then says is it won't end. You are Ramaphosa Defense Force. Just start acting professionally, it will end automatically. But what is he talking about? Malema says in his speech, that is what Ms. Haffajee says. Mr. Malema is entitled to say, I am not going to stop. Because what Ms. Haffajee is asking is that the EFF must stop saying these things in their speech. And he is entitled to say it won't end. And the reason he says it won't end is perfectly aligned to his original complaint, that certain journalists have positioned themselves to defend President Ramaphosa and to defend Minister Gordon. Mr. Malema may be wrong, for all we know. But he is entitled to position those journalists as part and parcel of the Ramaphosa Defense Force. And then the next line, just start acting professionally, it will end automatically. Of course, he says, my own conduct in labeling you as Ramaphosa Defense Force will end if I no longer perceive you to be the Ramaphosa Defense Force. We are then told that now you must focus on the EFF trolling army. But if you want to establish a case under Section 10, the trolling army is irrelevant because the imposition is directly on the EFF. If anyone pretends to be an EFF supporter and then starts abusing journalists, that person must be brought to court. The next tweet is from Mr. Shivambu. And your ladyship will recall that we are deliberately selecting EFF tweets so that if your ladyship, I think Ms. Van Wyk, he says, I think a lawsuit against a confused, conflicted, and drowning young investigative journalist like Polly Van Wyk will be tantamount to killing an ant with a 6-inch hammer. But here are the most important words. Forget about the first one, the first portion. These are the types we clarify and cogently dismiss with facts. Demand for concrete facts, and they fall on their swords. Again, this is the second time a prominent member, leader of the EFF, a deputy president, explains the position of the EFF. Mr. Malema told the world that we thrive on superior logic. The deputy president says we dismiss and clarify these types with facts. We demand concrete facts, and once we do that, they fall on their swords. No one sensibly can say that amounts to hate speech. At page 64, Mr. Shivambu appears again. He is responding to a tweet by Bongani Bingwa, which says, there are growing calls to no longer take EFF public addresses live, but to preview and fact-check them, and also to edit them to exclude incitement and violence and defamation. Good call or censorship? So if your ladyship just looks at that, there is a discussion that the EFF must be censored beforehand. When they speak, you must not do what you do to the DA or the ANC, where you allow everyone to speak without prior editing. For the EFF, you must first view the video. When whatever you deem as incitement, exclude. Whatever you deem as defamation, exclude. There is a call for the censorship of the EFF. Mr. Shivambu responds to that tweet when he says, so the madness of Max du Preez is a growing call now. The EFF doesn't need the media to carry out events and articulations live. we have adequate capacity through social media platforms to reach out to our people directly. Rational media platforms will also not comply with madness. Of course, this is tough language, this is hard words, but perfectly understandable in the context where the very existence of the EFF is threatened by the conduct of the media, which wants to pre-screen everything it says, and then take out what it doesn't like or what it considers to be defamatory. And Mr. Shivambu's response is actually a fairly neutral response, because this is about squeezing the air out of the EFF. Mr. Malema reappears at page 87 in response to Ms. Munusami. Now, this was a debate about what had happened in Parliament around Mr. Ismail Momoniat. And then Ms. Munusami says, if you do not know who Ismail Momoniat is, ask. There are many people, even people you might consider to be inferior like me, who could help you. Happy to help anytime, sir. You see, my lady, the journalists routinely communicate on Twitter, not news, but social discussion, political discussion on Twitter. They are not publishing a newspaper. Mr. Malema then responds, we know him very well, and we also know why he is treated special by those who do not respect, who have no respect for African leadership and African colleagues. Again, this is a neutral statement. He is simply complaining that Mr. Momoniat either has no respect for African leadership, or people who have no respect for African leadership treat him specially. Mr. Malema, again, is at page 88. He's talking to Mr. Shivambu, where Mr. Shivambu tries to engage his point about clarifying cogently with facts. Mr. Malema says, don't over-explain yourself, my brother, Floyd Shivambu, to embedded journalists who have made it their business to misunderstand us, but prepared for worse because you trust the untouchables and the favorites of the media. That, again, is a neutral statement. He's simply saying, don't waste your time trying to explain yourself to journalists because they will deliberately misunderstand you. At page 89, this is now the Deputy President. I've shown your leadership tweets coming from the President and the Deputy President. I'll come to others that come from other leaders of the EFF, and you will see all of them. There is absolutely nothing hateful in their tweets. It says, we know we have hit the nerve, even when those who pretended to be neutral journalists throw the toys and go on full defense and baseless exoneration of one individual who evidently micromanages national treasury. Fact is, he undermines Africans. Again, that statement is perfectly neutral and perfectly legitimate. Then at page 99 is a tweet by Lee Matthys, who is the treasurer of the EFF. She is responding to Ms. Nomboniso Gasa, who says, nothing stops the EFF from seeking remedy in courts. Then the response is, and nothing stops us either from calling out the inconsistencies in Pauli van Wyk articles. As she does her job, we must be allowed to do ours, and our response will be determined by us. So again, we have another, this is now a third leader of the EFF, explaining the position of the EFF. We are entitled to call out what the journalists are saying. There was an emphasis placed in the tweet at page 140 by Mr. Malema. Now, this was a reply to Ms. van Wyk, who stated that the EFF, Mr. Malema must take responsibility for violence meted out to journalists. He's stoking the flames of a campaign against journalists whose work he disputes and ultimately endanger the lives of journalists. Mr. Malema says, you are sick, go to hell, Satan. And that was read out yesterday explicitly. Of course, that could be construed crude, that could be construed insulting. And of course, it could be construed as even offensive. But it's not hate speech under Section 10 of the Equality Act. It's certainly not the hate speech that the applicants are contending for, which is discrimination on the grounds of profession. So to insult someone by telling them they are sick and they must go to hell is not hate speech. It's an insult. And it is absolutely essential to draw these distinctions. And they have been drawn for us, luckily, by the Supreme Court of Appeal. And if your ladyship just has regard to the words that were in the Masuku case that were held not to constitute hate speech, they are at page 55, at paragraph 6. Where Mr. Masuku spoke about subjecting people to perpetual suffering until they withdraw from Palestine. And the response of the Supreme Court of Appeal to that, at page 26, paragraph 59, saying these offending terms.
Page 59, paragraph 26.
Yes, page 59, paragraph 26. The terms may be irrational, offensive, or insulting. And that has nothing to do with hate speech. And nothing more needs to be said about that tweet. The fact of the matter is that it does not reference the journalism, it doesn't reference any of the prohibited grounds under Section 10 of the Equality Act. At 141, Mr. Shivambu speaks in response to Ms. Van Wyk, and he says, laughable fishing expedition, Mrs. Lakay. Well, that's it. It's a laughable fishing expedition. There was also reference to the tweet by Mr. Mpofu, Advocate Mpofu, at page 142. But let's look at that tweet. Remember what happened. At page 148, Ms. Van Wyk has done her job as a journalist. She has sent questions to the EFF on email. She is concerned that there is no response. She doesn't write an email to the EFF asking for a response. She tweets about it, telling the whole world. She says, I've sent a few questions, read the illicit VBS, to yourself, Mbuseni Ndlozi, on Monday, and that you haven't answered. Advocate Mpofu, just a reminder. At 142, this is Mr. Mpofu's reply. So, does that give you license to publish blue lies and fantasy about me? And we know the article, it refers to Mr. Mpofu having something to do with the patients of the house. And he says that's blue lies and fantasy. I have not seen any questions from you. He's responding to the tweet from Ms. Van Wyk. You never called me. Again, he's rebutting what Ms. Van Wyk is saying publicly. This is put by Ms. Van Wyk on Twitter. And then says, like you, I work for a living. I'm not your garden boy who must jump at the exact time that you feel like doing your day job, Thursday. There is nothing hateful here in terms of Section 10 of the Equality Act. The first two passages are a perfect response to why are you putting this on Twitter? If you say you've sent an email to the EFF, there is no reason to then tweet about it. And to say that I'm not your garden boy and I don't have to jump at the same time as you has nothing to do with discrimination on the grounds of race or abuse on the grounds of race. Simply saying you are behaving like a madam. That's the accusation. And Mr. Mpofu is the chairperson, national chairperson of the EFF. At page 148, Mr. Mpofu appears again. He has responded at page 147, and at 148, immediately after the tweet from Ms. Van Wyk, he says, actually, if you read the rubbish article carefully, it's a dishonest retraction of the claim that 10 million VBS money went to Floyd personally. We challenge her to prove it. We are still waiting. Again, this is a public response because things that should have been done on email have been put on a public platform. And what he is saying here is that you are dishonestly retracting the accusation that was false, that Mr. Shivambu got 10 million rands from VBS. And then the next one from the leadership is at page 153. And this is from Mr. Mbuseni Ndlozi, who is the national spokesperson of the EFF. And you will see, Your Ladyship, that this is a response from Ms. Van Veer, who says, again, let's just correct the distortion. It is EFF people stealing from the EFF and its constituency. The EFF is not some unparticipating victim that woke up robbed. And Mr. Ndlozi says, this is a story about people who are stealing from EFF, yet Sunday Times, with its malicious headline, seeks to create an impression that EFF is caught with their hands in the cookie jar. Nothing more needs to be said about that. You will recall that extensive reference was made to the tweet which appears at 221, and this again comes from Mr. Ndlozi. And this is in reference to the Vodacom issue. And I'll show Your Ladyship exactly what the facts are around Vodacom. Fighters, don't be surprised when Vodacom gathers journalists to strategize on how to deal with the EFF. It just means our fight is right where it belongs, in the belly of the beast, white monopoly capitalism. Hashtag white monopoly capitalism. We would not be doing well if they were not all uniting against us as a jig. There is no hate speech here against anybody. There is not even a creation of an atmosphere of abuse. What he is simply saying is that we are pressing the right buttons, and we should continue pressing the right buttons, because that is why even Vodacom is opening up a platform for our criticism. Now, my lady, you remember the debate yesterday about whether context matters at all. We know context matters because of paragraph 27 of the Masuku case at page 59, where the Supreme Court of Appeal says these statements also failed to be interpreted within the context of the speech and the circumstances attended at the place and time they were made. What was the Vodacom context? Because you remember, the suggestion is the EFF called upon its supporters to react to Vodacom. The Vodacom stores were trashed, and therefore we fear that we will also be beaten up. We know for a fact that the EFF says in the answering affidavit in relation to the Vodacom issue, at page 379, paragraph 349, this is what Mr. Malema says. I point out to the court that 6 individuals who purported to act in the interest of the EFF when causing damage to a Vodacom store in Polokwane were held personally accountable for their unlawful conduct. Neither the EFF nor I were held accountable for such conduct. The EFF as a political party and me as its leader should not be held vicariously liable for conduct over which we have no control, and in any event have encouraged our supporters not to engage in. 20th of November 2018, Mr. Malema said violence is for the empty-headed. In the EFF, we thrive on superior logic. They expressly called against violence. And they specifically say those individuals who trashed the store bore the consequences of their conduct. We know this as well because the newspapers that have been attached, newspaper articles attached to the application, 224 in particular, at MD 13. This is what the newspaper says. 6 arrested for quote-unquote EFF Polokwane Vodacom store damages. And then it says, the police said they could not confirm the political affiliation of the suspects who handed themselves over to the police on Thursday. 6 people have apparently handed themselves over to police in connection with damages caused to a Vodacom shop at a mall at the weekend. And then he says, he added that the police were still continuing with their investigation. So even the police, who are primarily charged with conducting the investigation, said they couldn't confirm the membership. And it's quite easy for anybody to trash a store and steal a couple of cell phones using Mr. Malema's name, in conflict with what Mr. Malema has said, where he has expressly said violence is not for us. And then at page 226, how that story ended, the Vodacom story. Is Vodacom and the EFF had their own discussion. They then issued a joint statement saying, as far as we are concerned, the dispute is over. It is now resurrected by journalists who are not involved in the dispute. So we see the statement at page 226 to 227.
Also, their discussions happen in private and not preemptively put on Twitter, which is the point that you made earlier.
Yes. And what the statement says, the fourth paragraph. In the meeting, the parties discussed the matter in detail and have resolved the issue. Vodacom acknowledged that it is politically neutral and it doesn't influence party political positions in any way. Vodacom and EFF appreciate that the matter could have been handled differently to avoid the misunderstanding that occurred, the EFF and Vodacom said in a joint statement. Page 227, the parties said they encourage the right to freedom of speech and the free circulation of ideas. The EFF and Vodacom also committed to engage on policy issues of mutual interest and considered the matter now closed. That is how it ended. 6 people decided to trash a Vodacom store. No doubt they stole a couple of cell phones. The EFF and Vodacom took the responsible line. They had a meeting, they discussed, they resolved their misunderstanding, they issued a joint statement. So the attempt now at dragging that issue up and then putting it somehow as evidence of the, I think someone called it a violent streak of the EFF, is really to stretch the bounds of credulity beyond breaking point. And so that context is crucial for understanding the tweet at page 221. And understanding the tweet at 251 by Thengiwe Mkhaliphi, who is the Deputy Secretary General, where she says, Vodacom have declared a war against the EFF, let's go. Let's see who will win this war. Fighters, let's go. What we know is that there were in fact protests, but those were protests outside of the stores of Vodacom. And the right to protest is in the Constitution, provided it is not done violently. And so there would be no problem at all with Ms. Mkhaliphi says there is a war declared, let's go. Because that simply is a call to protesting at the stores of Vodacom. And as a matter of fact, those people who exceeded the bounds of peaceful protests got themselves locked up, and no one actually knows what their political membership is. Then, Your Ladyship, you were referred to 247. Now, that's the retweet. What we know about the retweet is that it is a retweet by Mr. Malema. But we also know his explanation about retweeting. Oh yes, at page 380, paragraph 355.1. This is what is in the answering affidavit, an explanation about the retweet. Now we remember that Mr. Perry Bateman accused Mr. Malema of endorsing the tweet. Mr. Malema says in paragraph 354, the insinuation of Mr. Bateman is denied, expressly denied. 355.1, I said nothing further in respect of the retweeted statement. My silence cannot be construed to mean anything further, particularly where doing so would have unlawful consequences. He expressly distances himself from the endorsement. I regularly retweet tweets that I both agree and disagree with. A retweet is not an endorsement or akin to a like on Facebook. Instead, it is a means of drawing attention to something that you may see by showing it to the people who follow you. That need not mean that the contents of the tweet is endorsed. That is the explanation he gives in the answering affidavit. And then he continues the following page at 381, 355.3. It is common practice on Twitter that various persons include a disclosure in the description of themselves that features on their Twitter homepage. While I do not have such a disclosure, it is frequently the case that people say things like likes and retweets, not endorsements. This is done for various other reasons other than to show agreement with a particular tweet. In consequence, the court should reject Mr. Bateman's attempt to dress up my retweeting a tweet as evidence of a breach of the Equality Act. So this is expressly denied, and it is explained fully that retweeting is not endorsement. But we know on the facts that this was immediately deleted at any rate, shortly after the retweet. But context matters, my lady. Context matters because we are told so at paragraph 27 of the Masuku case. What actually happened here? So that we don't have a skewed and a narrow understanding. Mr. Jacques Paul tweeted what at the time was understood to be the address, the actual picture, with an arrow showing the house of Mr. Malema. I know Sanef says that they objected to it and they distanced themselves to it. But the fact is that it was tweeted. Yes, and the point that Mr. Malema himself actually makes at 379, page 351, says, although Mr. Bateman records the unlawful and unethical conduct of Mr. Paul in publicly sharing what he believed to be my home address, together with an aerial picture of the house, it serves to demonstrate that journalists, including some of the complainants, do not conduct themselves according to the ethical standards that one expects. I mean, Mr. Paul acted as a journalist, widely condemned by the journalistic community. And the fact is that Mr. Malema's house was tweeted by a journalist, not published in the Sunday Times newspaper, but on Twitter. So Twitter is a platform that journalists themselves use to communicate issues that express their opinions and issues that do not necessarily are newsworthy.
They deleted it, and no one better than I did, so why is Malema's unretweeting any different?
Yes. My colleague points out to me that when Mr. Paul deleted the tweet, and no one complained, but Mr. Malema unretweeted this tweet, and that too is held against him. But the point of the matter is that in the answering affidavit, Mr. Malema explains that a retweet is not an endorsement. And when I retweet, I am not endorsing. And that it is common practice on Twitter that people will press the like button or the retweet button, and that has no implication of endorsement at all. But nevertheless, what does the retweet say? 247, a list of Stratcom journalists' home addresses would be a good Christmas present. That, of course, is wrong. No one should be going around looking for the home addresses of journalists. But it is not hate speech under Section 10. I've dealt with the tweet at page 251 by Ms. Mkalipi, and I've shown the full context of the Vodacom story and the rather opportunistic nature in which it has been parachuted into these proceedings. Then, my lady, in the replying affidavit from Mr. Basson at page 513, again, something was made of this in the main address. Remember what had happened is that the Black Land First organization had said something that are awful about killing of journalists. Someone else who purports to be an EFF supporter then says, for the first time, I actually agree with Mr. Mutama. Again, that's crucial to draw that distinction that it's not the EFF that is the original source of the threatening tweet. It is Mr. Mutama. And a third party then says, I agree with him. Mr. Basson then raises this issue and then says upon Mr. Malema, I've opened an intimidation case against, a criminal case of intimidation against an EFF supporter threatening to kill me. Very unprofessional. The SAPS is very unprofessional and very professional rather, sorry. And I will assist them in tracking down the suspect. No condemnation yet from the EFF. And then Mr. Malema says, we won't do it. The question then that arises is whether that response, we won't do it, constitutes hate speech. The answer is manifestly no. The mere fact that the EFF refuses to condemn someone who is behaving crazy does not mean the EFF is committing hate speech. The same thing, that tweet goes on to page 514, where Mr. Basson says, well, what won't you do? And Mr. Malema responds, condemnation, as we will condemn no one. That simply doesn't constitute hate speech as defined in section 10. Now, my lady, this is the full extent of the tweets by the EFF itself. This is the full extent of the tweets that would fall under section 10 of the Equality Act. Why this in-depth analysis is important is to ensure that we do not blur the lines, we do not attribute legal liability where the statute doesn't impose it. What picture do we get out of these tweets? There are big messages we get from the tweets. The overall message is that the EFF is extremely unhappy with journalists that have taken political sides. But the way it has decided to respond is what Mr. Malema calls superior logic, what Mr. Shivambu calls clarify cogently with facts they fall on their sword. That is the dominant, most reasonable construction of the actual conduct of the EFF. What is the position of the EFF on violence? Not only did the answering affidavit expressly repudiate violence, the very first speech that brought us to court on the 20th of November, Mr. Malema made his position clear on violence. That clarity on violence has been repeated many times by the leaders of the EFF. Mr. Shivambu has repeated it. Mr. Ndlozi has repeated it. Ms. Mateus says we are entitled to respond whenever we feel we are criticized. Mr. Mpofu's tweets are also quite clear that do not lie publicly and say you phoned me. Do not lie and say you sent me questions. You didn't. All of that is perfectly legitimate, protected by Section 16 of the Constitution, which the EFF relies upon also to propagate its message. But most importantly for our purposes, my lady, it's not an infringement of Section 10 of the Equality Act. This is where our learned friends then move on to another cause of action. And then they say, well, if you did not directly commit hate speech or violate Section 10, then you are guilty of violating Section 11, harassment. My lady, I think I still have 3 minutes. My junior probably thinks I've spoken too long. So he's reminding me that it's tea time. Yes, I still have 3 minutes. Let me use it. Let me use it, my lady. Thank you. So that takes us to harassment. We know the definition of harassment under the Act, and it's again crucial to be strict on the language because that is the caution we are given by Dr. Milo. 69, page 69, section 11, no person may subject any person to harassment. So again, we know, in the same way as we know of section 10, that the prohibition is directed at the EFF. But the language is broadened by the definition of harassment, which is at page 65. Harassment means unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences. And which is related to sex, gender, or sexual orientation. So on A, we know for sure that this is not a case that falls on A, because it's not about sex, gender, or sexual orientation. On B, a person's membership or presumed membership to a group identified by one of the more of the prohibited grounds. Now again, you go back to the prohibited grounds. This is unlike, my lady, a situation where the language of the Act, like in section 10, says any other ground. This is a situation where you must fit in the grounds themselves. So you must sex, gender, sexual orientation. None of those apply. Membership to a group identified by one or more of the prohibited grounds. So you must be within a group that is identified by one or more of the prohibited grounds. So if we look at what are those groups, race, gender, sex, pregnancy, marital status, ethnic, social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, birth, HIV status. This case does not fall within those because there is no characteristic that they can point out that is linked to the characteristics in B, in A, which is prohibited ground. Because the language of section 11 is quite clear that, the language of the definition of harassment is quite clear that you have to be identified by one or more of the prohibited grounds or a characteristic associated with such group. In fact, my lady, the language in the definition of harassment tracks the jurisprudence because it focuses on this innate characteristic. What it doesn't do is the leap of logic that Sanef is edging upon the court, which is ignore the prohibited grounds and simply adopt occupation or journalism as an exception or a prohibited ground. You see there's lots of activity behind me, but the time is also 11. I wonder why. The time is also 11:15. I probably have no more than 20 minutes to continue, and then my colleague will then do the strikeout. Thank you.
You would think sitting down is nice.
How are you?
The two of you.
No. Not you. You want to say, when you say, and then the tweet from this one.
There he is seated at the back of the room, my lady. There he is seated at the back.
Here, how are you? Good and you? Yeah, we know we need to say that.
It like worked like a feminine child. I said Dolly, and then Dolly came out and child like
Can I eat all of this?
This is still kind of like.
Okay, yeah.